Okay, we're back on the record in State of Wisconsin versus Samantha Krebs. It's Outagamie County Circuit Court, State of Wisconsin, file 24 CF 921. The appearances are the same. Ms. Krebs, at this point, the court's going to walk you through my analysis and ultimately my decision on the disposition. I want to stress to you up front, and hopefully that's indicative in my tone and demeanor, that I'm not deciding the disposition in this case based on anger or excessive emotion. Trying to do my job in a tempered, professional and reasonable way, considering all the factors and categories that the appellate courts and our Supreme Court tells me to follow. Up front, I'll explain to you some of the technical things that judges consider at sentencing. There's categories that by law judges are required to cover during sentencing and some factors within those categories. Often they're referred to by case name. The attorneys have already referenced some of them, including the Gallion case, the McClary case. Overall, what those cases tell trial court judges, including me, is that we have discretion at sentencing. Some cases we don't have as much if there's mandatory requirements. However, even in this case, there's some discretion that falls on my lap. And what I may do here today may be different than a judge down the hall or a judge one county away or a judge on the other other corner of the state. And the appellate courts and our Supreme Court have said that's okay if we do things differently. We just need to make a record as to why. So during this process as we go forward, it's going to take some time because I want to be as thorough as possible. I'm going to explain to you the categories and factors that I've considered and ultimately where we land on a disposition. The main categories at sentencing include your background and rehabilitative needs. Second is the seriousness of the offense that you're convicted of. Third is the rights of the public, including any victim's interests, and we have multiple individuals that are victims in this case. Within those broad categories, I consider everything submitted to the court, including everything in the pre-sentence report, the letters that have been submitted on both sides, the statements here in court today, including from you. I also consider the attorney's arguments. I often spend a lot of time on sentencings, even in major cases, on my true interest and sincere interest in rehabilitation. As commented on, the system is in most cases set up to give people second chances. Sometimes it turns out to be third, fourth, fifth chances or more. But it's rare where a judge is presented with a case where they just say, well, we're just going to lock somebody up and throw away the key. That's something I'm not interested in. But each case kind of comes forward on its own merits or lack of merits and obviously all the factors that I'm required to consider. So I do acknowledge for the record that you continue even at age 40 to have serious treatment needs. Some mental health, but overwhelmingly for the last 2 decades is addiction. And so this record that I'm creating is not going to be void of a discussion on addiction. And some of it has come up in the trial and some even here at sentencing on Joseph John Carnot and Joey Carnot and some of his addiction. But I'm not deciding the disposition in this case or whether there's going to be a parole eligibility date or not based on anything in Mr. Carnot's background that may be considered negative to any degree. He is the victim in this case, along with his family members. And while I am going to focus in part on treatment for you going forward, want to acknowledge for the record that no matter what ups and downs Joey had in his life, his loss is a great loss for our community. That's acknowledging somebody who, I think for the most part, at least on paper and what came across as at trial, was somebody who was in his mid-30s, he was struggling. But often in his life, he persevered. He got over some hurdles. And although you've not been part of the community here in the Fox Valley for very long, I think Joey's story is common to a certain percentage of our community where you don't like hearing about the struggles and the family members don't like enduring the ups and downs, but there's always hope that he's going to turn the corner or she's going to turn the corner, whoever's in our community struggling. So if I read my paperwork correctly, he was born in October of 1988, was taken from us in July of 2004, so just short of his 37th birthday. So he's 36 years old. And those 36 years, probably most importantly, as came across from family today, the involvement of him being a dad was the most important. The court system often gets parents into court who are struggling, and part of the analysis for a judge is, are they going to be back with their family? Are they going to have time with their child? And even though it wasn't my case, I know from what happened at trial and what was referenced that something important going on in Joey's life in July of 2024 was that he had a court date on July 31st, and you were aware of it. You referenced it, I think at least in one of the pages of the pre-sentence report, but I think it also came up at trial, that he was trying to get at least mentally prepared and organized for a court hearing on July 31st in Winnebago County regarding the scope of his time with his son. You expressed that you were supportive of that, and that's appreciated. In the end, what probably would have taken place was some sort of analysis by the family court commissioner or the judge in Winnebago County as to where Kaysen's dad was at with his addiction. And as his mom pointed out, and I think even Ms. Hippis at trial pointed out, there were ups and downs. Joseph's record of accomplishments should not be understated. His education, his work, his military service, his perseverance through tough times. In many ways, he represents a good percentage of maybe the kids we see from Kokana that come into the court system. They're usually from hardworking families, labor families. The community over there in Kokana is probably not too dissimilar from your community in Wisconsin Rapids. Good labor communities, people work hard, but on the flip side, they also play hard. And I think Joseph, or Joey, is pretty indicative to a segment of that community where hard worker, good family background, some rough edges. And if I use Kokana speak in a way, some people would probably refer to Joey over in Kokana, and this is said in a complimentary fashion, if you know people from Kokana, they'd probably refer to Joey as a good shit, because that's how they talk in Kokana. And that's not an insult to Joey, it's just that he's got some rough edges, and but in many ways lovable, even with the warts or the bumps and bruises. It's somebody you kind of go back to and you root for. Your upbringing and didn't have to be dissimilar from his. In fact, for the most part, when I look at your treatment needs, You didn't have much through high school. If we're to believe everything you said in the pre-sentence, you had a decent education, you had decent family support in the Wisconsin Rapids area. There was some negative influences that cropped up, including from one of your siblings, but pretty much from 18 forward, not every month or every year, you're involved in the court system. And that's important for me to analyze when it comes to your treatment needs and a decision regarding whether you're even eligible for parole. And I'll pause for a second to stress to the people, not just at the tables, but in court, that if the court decides on some parole eligibility date, it's not a guarantee that it happens that date. In fact, the paperwork I handed out under 302.114 just simply makes a person eligible. And then a parole board decides that, not the judge. So a person could get a parole eligibility date after 20 years, which is the minimum. That person may never get out. Some of it depends on behavior within the institution, and as pointed out in the statute handed out, there's things that reference the distinction between good time and bad time regarding behavior in court. But going back to where I was at on your path in life, somewhat in contrast to Joey's, there were different times where there were interventions to try and steer you to a different path. And I'm going to comment on some of your prior history, not to kick you while you're down or give you a hard time, but to document for the record what efforts were tried, at least over the last 20 years. Going back to some of your earlier cases in Wood County and Wisconsin Rapids. And it's not brought up to second guess a judge that somebody might say went too hard or too lenient on you. It's brought up to put context to your journey coming forward to July of 2024. And the prosecutor pointed out, the district attorney, Ms. Templis, pointed out at least a certain number of convictions. Her calculations may have included criminal traffic. At least when I calculated, maybe setting aside criminal traffic, there was at least 26 convictions. It's not brought up to embarrass you. It's not brought up to give you a hard time or second guess what the system did or did not do years ago. It's simply to bring up context. And I guess the overriding thing is to say, as you sit here at the table and as you're living in our community in July of 2024, you were not a naive person. You were 38 years old. You had a certain level of education that we expected at age 38 to have some wisdom. And that's not just in the classroom in Wood County or any classes you may have taken at technical college after high school. It's the collective wisdom of your life experiences, which includes not just traditional classroom setting, it includes the ups and downs of a childhood or teen years. It includes the school of hard knocks or life on the street, and your involvement in the court system, the ups and downs. And what that means to me and to most judges is the amount of collective involvement you have, that we expect some degree of wisdom from the educational experiences that are traditional and good, and even some of the negative things in your life that should have taught you some level of wisdom, some degree of maturity and wisdom where when you face a frustrating situation later in life, you can pause, you can react not by emotion, but some degree of reflection from the negatives and the positives in your life, and do something at first instinct that is more honorable. That maybe there's an instinct in you that's developed where you react in a positive way to a alarming situation. So that's part of the court's analysis going forward is, where was Samantha Jean Krebs in her life in mid-July of 2024 to the point where she could have paused and reacted in a way that we'd still have Joey here today and not even have this court case. And that's important because even as you're going to be incarcerated on any type of mandatory sentence or mandatory minimum, the court has to consider your treatment needs, because I think it's intertwined in the fact that under the statute that I provided, I have to make a decision on whether there's parole eligibility or not, and treatment's part of that. You need treatment, even if it's in a confined setting. You've got an addiction history that's in many ways jaw-dropping. It's not just head-scratching, it's not confusing, it's the fact that different efforts and different treatment programs have been tried and they're cited within the pre-sentence report. And even when you've had the alarming life experience of going to prison before, you get out and months later you gravitate back to the drug culture, to your circle of people that you can get drugs with, or spend time with and use together, or even based on your history, there's times when you've had charges where it's possession with intent. The community you decided to move into, whether it was 2 years ago, 3 years ago, or roughly somewhere in the middle, my opinion is that this community is an empathetic community. People are in favor of second chances. I think there's times where Joey asks for second chances or third chances, and his family and friends and the court system at times had to decide that. So it's not a cold community, it's a welcoming community. And whether it's services within the court system that Ms. Templis talked about, treatment programs, or from private entities, charitable entities, we want to see people turn their life around. So you come to this community, and I don't know what your complete motivation was. Maybe it was a job, maybe it was Joey, maybe it was something else. And for the most part, it looks like you were welcomed in. There's good jobs here. There's a good educational system here. People are generally upbeat. They're enthusiastic about things such as sports, the Packers, the Brewers. There's countless community festivals. It's a place people want to be. That's probably why Joey stayed here. So that's you crossing the threshold into our community. And you, maybe it was to get away from Wisconsin Rapids and some of those influences that created the long record of 20-some plus convictions. And that's not something distasteful or motivated by a bad reason to come here, but once you get here, there's some expectation that you're going to try and do better. And I don't think Joey was trying to discourage it. The messages Ms. Templis brought up suggested a positive vibe regarding his view of your relationship. So he's somebody who, at least the record we have here, wasn't somebody who was tormenting you. Maybe there's some times of frustration or agitation, but it wasn't something where you were in a domestic relationship that was tormenting. The cloud or the haze over the relationship was the addiction aspect of it. And as pointed out by Joey's family members, and I think that was consistent with the trial testimony, you know, he had gotten to a clearing or a time in his life where he was on the mend. He was in a good place. And there's nothing wrong with people jointly in recovery or in a sober environment or in the sober community relying on each other on their path going forward. So Joey's treatment efforts and recovery efforts were honorable. Your at least stated desires to get better on the face of your words are appropriate, but the issue is then what did you do to follow through with it? And that's where we run into trouble and ultimately where worlds collide and something bad really happened. I'm all for your treatment. I'm all for your recovery. I think a community as a whole was all for that. But at some point, judges, attorneys, people in the Department of Corrections, law enforcement, anybody in the recovery community has to say, well, how many more efforts are we going to make? And what has this person left in his or her wake where we just got to say enough is enough? So there's a balancing, and this is where we kind of transition from that first thing, your background and treatment needs, to the seriousness of this offense. It's a homicide. There's no sugarcoating it. It's an intentional homicide. And the definition of an intentional homicide, I know that was stated by one of the earlier witnesses today, has some broader aspects than one might think. It could be somebody who plans out a murder or a homicide and acts on it and follows it through premeditated, clearly intentional. Our jury instruction says, well, the thought of it only has to be a few moments or a few seconds before it takes place. Or it could be somebody who does something that's practically certain that death will result. So if you have you, who admittedly was using methamphetamine, have access to a dangerous item, a knife, and whether you had thought about it for a few minutes or you're just in anger or frustration, you plunge a knife into another human being and it results in his death, it's not a big surprise that the jury's going to find you guilty. That's a simplistic summary of what happened. There was a lot more to it, but that act itself, even if it was thought about for 5 seconds, 10 seconds, a minute, it doesn't have to be calculated and premeditated over a period of days. And somebody on the outside could say, well, these people were using drugs or the defendant was drugged up. Isn't that a mitigating situation? Maybe in some circumstances, but when you have a 20-year history of being immersed in the drug culture, at some point you know some of your use of drugs, whether it's meth and you've got some heroin in your background, amphetamines, THC, there's a collective knowledge from being in the drug culture that people do bad things when they're not always in their right state of mind because they put things in their body, such as meth or heroin or marijuana even. We've had homicide cases involving that. So Samantha Jean Krebs, at age 38 in July of 2024, was a person who, whether she had been cavalier about life or just didn't care, was making a priority getting meth and putting it in her system. Now, if you're living on your own in a house or an apartment and you don't go outside, maybe that doesn't hurt other people. It's a pathetic situation and anybody would wish you help if you were that person. But you chose to engage in a relationship where maybe the water in the fish tank that was referenced wasn't exactly Joey, but the waters were getting pretty clear for him. And when you get cross paths with Mr. Carnot, that fish tank didn't get cleaner. The water got dirtier. And that's not to say you put a gun to his head and told him to use drugs, or to hang out with you when you were in a bad state of mind, but there was really an imposition of a theme or a will on your part to draw them into the culture you were so familiar with for basically 2 decades. Doesn't mean something violent had to happen, but in some ways your history is important to recount because, once again, I'm not resentencing you on an old case or criticizing anybody that was involved in the disposition on these cases years ago. You do have prior cases where you put people at danger, and some of them involved the use of a dangerous weapon. Even most recently, just the using of drugs and providing it to others is important because that just shows it's not just you immersed in your addiction, it's you willing to roll the dice and put others at risk. Your Wood County cases, even from in the last 3-4 years, 22 CF 543, possession with intent regarding methamphetamine. So that means you're not just using drugs for yourself, you're making it available to others. Wood County case 20 CF 217, possession with intent of heroin, which anybody that's around that drug with any degree of knowledge, not even somebody with, like you, with a honors degree from a high school, would know you put heroin in somebody's body or even in your own, and it's a flip of a coin whether you're going to live or die. Possession with intent of heroin in 2019. So at least 3 cases in the last 5-6 years where you're putting other people at risk. Now you got some cases a few years back where maybe not all domestic, but at least some confrontations with others where you did something physical. You got a disorderly and a bail jumping in 2011, a case in Wood County where you bit a male individual. You got a felony case in Wood County in 2011, which is 2011 CF 16. It got reduced down to a battery and a bail jumping, but this is part of all the public record and referenced in the pre-sentence report. Even as early as 2011, you're charged with substantial battery because you have a confrontation in a driveway with a male individual and you crack him over the head with a bottle. He gets stitches, so it's charged as substantial battery, but the case gets pled down. So at least likely in a state of mind where whether you're drinking or using drugs, you engage in violence towards another, a male individual, by cracking him over the head with a bottle. So it's not just you isolating yourself using drugs or alcohol or, feeling sorry for yourself, isolating yourself. You're engaging with others and things get violent. The DA referenced the Wood County case from 2016, 16 CF 490. It got pled down to a lower felony, injury by negligent use of a weapon, but the reality is from witness statements in the complaint and ultimately the original charge where there was least probable cause, you were charged with first-degree reckless injury from September of 2016 in Wisconsin Rapids, causing great bodily harm to an individual named Tyler with the last name L, with the letter L. So what's happening then? It sounds like you're both using. You're at a residence on Wisconsin Avenue in Wisconsin Rapids. He's playing with a gun. He's spinning it around in his finger, and he passes it to you. It's a Ruger revolver. According to the victim and other witnesses, Samantha takes the gun, firearm, aims it at Tyler's right thigh, presses it up against his thigh, and pulls the trigger, discharging a bullet into his leg. Now, when there's a follow-up interview, it's alleged that you asked him, is it loaded or not? And he didn't answer, but you still fired it. once again, I'm not reopening that case. I'm not criticizing the judge or the prosecutor who pled it down. But the point is, you've at least by 2016 had multiple events where you're doing some pretty crazy things that involve violence. So there was a reference whether something in somebody's life should be eye-opening or an awakening, or the light bulb goes off, or there's a red flag saying, I need to do something different. Well, you already had chances to have that pivotal moment or seeing the light moment in 2011, 2016, and even when you get busted for the heroin offenses where somebody could have died, and you're already in your 30s, in the court's view, that's the time where you should have reflected and done something differently. Joey Carnot was not the first male individual, whether they used drugs with you or not, to get physically hurt or assaulted in some way by you. This was not the first time, July of 2024. So that at least steers an outside observer and to some degree this court to do a more serious analysis of, is this person dangerous? How much time do they need to be kept out of the community? Are they going to change? Sometimes there's an expectation that people just get older or wiser or just get tired of committing crime and they stop. Can't always bank on that, but as the prosecutor was speculating, does that make somebody going to be less dangerous in their 70s or 80s? We don't have a crystal ball. But you and your track record, there were so many times where you had an opportunity to do something different. And I don't doubt that at times, and the lawyers know this, that there's sometimes a limitation on resources where people are on waiting lists to get into treatment, or there's not open spots in certain communities, and a judge can order it, and it doesn't always happen. So, yeah, if I went through Samantha Krebs' history with a fine-tooth comb, are there times where the system let her down? Probably, no doubt. There's times probably where the system enabled you and probably should have done something different. But for the most part, the multiple probations you had, even going to prison and then being on supervision, there should have been some eye-opening moment of reflection where you say, I'm just getting too old for this, I'm tired of this, I don't want my life to be chaos. I don't want to have this maddening existence. I think Joey Carnot was to a point where he didn't want that maddening existence. So July's coming around, he's struggling, but he knows that Kaysen's mom is laying down a line where we're going to have a court hearing and this is going to get sorted out. So 13 days from the date forward of his death, he's supposed to be in court. And you referenced it, I think, in some of your trial testimony, and it's referenced at your notes in the pre-sentence report, that you were aware of that court hearing, and you were at least expressing a state of mind that you're going to get prepared for it. And as an outside observer or a family member for anybody on either side of that case, whether on Ms. Hippus's family side or Mr. Carnot's family side, what would you expect somebody to get prepared for that hearing? And your comment, and I'm paraphrasing, was that your preparation on, and knowing the importance of the hearing was you were going to buy a dress, or you did buy a dress. True? All right. And I think most judges or court commissioners appreciate if people come up into court in professional attire, or at least presentable attire. But with your history, the expectation, and I'm sure it would have been much more of a benefit to Mr. Carnot if you did have a hearing, maybe a note from a therapist or a doctor that said, Samantha's gone through some recent treatment, or partway through a recovery program. So the dress really wasn't going to mean much to a court commissioner or judge, but in your way of thinking, in July of 2024, that's what apparently was important to you. I'm going to get a dress. I'm going to make at least some impression on the surface of, hey, we're a good household, or I'm a good partner for Joey, and he should have time with Kaysen. There's a phrase that comes to the court's mind when thinking about that preparation for that July hearing, the family court hearing. It's the phrase, quote, window dressing, unquote. In the definition, and this is once again paraphrasing, window dressing, that phrase with the negative connotation, is referenced as something superficial, or, quote, actually misleading presentation of something designed to create a favorable impression, unquote. The jury trial testimony that Ms. Templis referenced, and for that matter, even your statements today, the question has to come up, is that something of substance, or is it window dressing? And as I sit here today, when you speak, and I guess reflecting back on your trial testimony, I repeatedly have in my mind, am I hearing something of substance, or is it just a dress? When she brings up suicide, you bring up suicide in your statements to here today. Is that something of substance, or is that your dress today? Your presentation? This case was about what happened to Joey on July 18th of 2024, but a lot of it equally was what happened after the fact. And I know your lawyer has had this situation, and Mr. O'Bear has had it over the years too, and the prosecutors have had it. I can't think of a case over the last 36 years of being involved in the court system where the behavior after the fact was so important and compelling to look at. The post-offense behavior, and we talked about the jury instruction 172, the after-the-fact behavior. Sometimes people flee, sometimes people hide evidence, sometimes they're deceptive. And we basically had, if I'm remembering correctly, the evening of July 18th, all the way to the point of apprehension at Veterans Village, where there was just an ongoing over and over analysis of whether there's substance or there's a dress. My words. And when I reference the dress, I'm referring to whether it's window dressing or deception. And what just overwhelmingly must have come over to the attention to the jury was, what does Samantha Krebs do on first instinct? Is it substance? Is it the truth? Or is it a dress? Is it window dressing? Is it deception? And over during the trial, through your lengthy testimony, and even just reference to things that you did, your acts, your words, your text messages, your social media, your voicemail message about Joey being at work, calls to others, statements to family members, the jail calls. It just came across that your first instinct is always deception. It's to mislead, it's to cover. And no doubt, that's likely what had a compelling influence on the jury. There wasn't any taking responsibility. Even if you had something in the heat of the moment that somebody might want to say, well, Judge, don't you think this might have been a reckless homicide versus an intentional homicide? That goes out the window in the first moments because you have somebody with a stab wound, supposedly your loved one, and even if it was gratuitously portrayed as an accident or a reckless or negligent mistake, in the heat of the moment, under the throes of an addiction, what does your instinct tell you to do? Well, when John and Ms. Cleveland got there, said, you're standing there, but you're not providing aid. We don't 100% know the timeline, but we know that it's at least minutes, maybe 5, 10 on the upward side. And the idea that Mr. Carnot has that wound is stunning. It's horrific to think about, but there's still a window of hope to save him. And what do? Well, you don't call 911. You call some friends, or they come over, and there's some discouraging of calling 911 or getting law enforcement involved. You're trying to collect items so you can get back out of there. And what really could have happened? Well, we know Mr. Carnot at least tried to get up, and Ms. Cleveland said he went on all fours, on his knees. He said, beyond his gasping and heavy breathing, he's saying, I need to stop the bleeding. And this is when she's there. So several minutes after the stabbing, he's still communicating. And what could have happened in the interim, even if you didn't have to physically put him in a car and drive him to the hospital? Calling 911, they could have gotten EMT, fire department, somebody maybe even at the hospital. And we're all smarter after the fact, but the reality is you letting him linger there and not helping him is probative of your state of mind and what you did. It's public record, but where you're at that address, just by Northland Avenue there, the apartment complex. If you do a search or a MapQuest, Appleton Medical Center is 1.4 miles away, 4 minutes by vehicle for somebody to come from the hospital. Appleton Fire Department number 4 is a half mile away. 1 minute drive time if you're following the speed limit. Somebody could have been there with professional skills to save Joey, but you didn't give them that opportunity. So when I talked about people having sympathy for people having addictions and doing self-destructed thing, I think that's obvious, that exists in our community. But when their behaviors over time put people at risk, put them in danger of serious physical harm or even death, that sympathy dissipates, or in many cases goes out the window. I don't need to go through all of it, but I agree with the prosecutor on highlighting just that timeline of deception afterwards. The magnitude of it, in many ways, probably for the jury, was overwhelming. The suggestion to John Pfeffer that Joey fell on a knife, or even getting on the phone with Officer Fulmer, think that was replayed multiple times. It had to weigh on the jury to say, maybe not their words, but my words, is this substance or is this window dressing? Is this a dress? And you buying a dress or you selling a bill of goods may have been comfortable for you, may have been instinctual, an instinct that you're so used to over the years, may have felt right for you, but that wasn't reality. I cited to the definition of window dressing. The only other site I planned on referencing relates to a poem that I think overlaps with this case and your behavior after the fact. And it's more than 200 years ago. And what this famous poet wrote was, quote, "Oh, what a tangled web we weave, when first we practice to deceive." And for you, the first is always deception. It's window dressing. It's taking people down a phony path. And in many ways, and I'm not interested in insulting you, you're not really good at it. The phone call with Officer Felmer, the feigned alarm, the social media messages, the text messages, the voicemail message, just ad nauseum at some point. You live in deception, but in the end, you're really not that good at it. And so what do you create? Yeah, you created a tangled web. And the prosecutor walked you through that on cross-examination. And you stumbled, you bobbed, you weaved, you changed things. And then at some point, and I don't bring this up out of anger, but I bring it up more as a person that's been involved in the court system for 36 plus years. So as an attorney, as a defense attorney, as a prosecutor, as a judge now, and as a person who hopes for people to get better. But for you, just creating that overwhelming web of deceit, and as the prosecutor's taking you through even how you reacted to the stab wound and whether there's bleeding at some point, I reflect more as just either as a parent, a grandparent, somebody who knows people in recovery, knows people who struggle to keep their kids because of addiction. And at some point, I don't know if she said it out of exasperation, but that's how I felt it was expressed. I'll borrow Ms. Templis's words. At some point, she just said, "Oh, Samantha." And so I say that again today. Oh, Samantha. You had so many opportunities to change, to do something different. And you're the type of person that, judges that do treatment courts, like you had over in Wood County, and I do one here, root for. Sometimes when we're screening people for treatment courts, they say, this person isn't bad enough. We want the high-risk people. So the system hadn't given up on you in 2024. There's probably people on the outside that would have said, "Are you kidding? Why are you giving this person another chance?" But that's what we're designed to do, is trying to take people that are in their darkest moments and bring them back to some sanity. And you were cavalier about that. You go to prison, you're on probation at different times, you're getting revoked, people still coming, you got some incredible deals with some probably good lawyering over in Wood County. And did you take any of those opportunities to say, holy smokes, I really dodged a bullet, I really need to see the light and do something different? whether it would have been me or the judges in Wood County that you were in front of, people were still rooting for you 2-3 years ago. And you going back to that was just a ticking time bomb for something crazy to happen. So I'm not here to yell at you, give you a hard time. It's just, once again, I'm sure whether it's your mom or anybody else here that cares about you, it's just like, oh, Samantha. And that's a deflating thing to say, because the system rarely gives up on people, despite the calls from the outside to lock them up and throw away the key. So I need to weigh the interests of the community, and at some point, the empathy and sympathy have an endpoint. It dissipates. When you have a 20-year history, 26 crimes, convictions on my part, and as the DA, maybe 37 with traffic, at some point the system has said, enough is enough. This person needs to be put away for a long period of time, and if there's treatment needs, it needs to be done in the treatment setting or in the confined setting through the Department of Corrections. So I balance your continued need for treatment, but the overwhelming factor that I'm relying on is the protection of the public. And this should not happen again to anybody else. I give you credit for times where you have good effort on your education. You had sporadic jobs where you occasionally did well, so I put some weight on that under the Galleon factors. At times, you did okay on treatment, but as the prosecutor highlighted, most of your probation involved negative results. Today, you don't accept any responsibility. It's a suicide, Judge. I'm not buying that dress. So, by law, the court puts you on notice of, with a life sentence, any extended confinement can be impacted by bad time. So I've given you a copy of the statute, but you should know that regardless of what the court does today, there are penalties from the Department of Corrections regarding bad time. 10 days for the first offense, 20 days for the second offense, 40 days for the third and each subsequent offense. You'll get a written explanation of determinate life sentence. The court, as part of the disposition, will order the restitution as requested. We'll give Ms. Rock time to file a request. She made a verbal request for a hearing, but we'll give her 21 days to file a written request, and we'll schedule a specific one. But the court is accepting the restitution as part of the original judgment of conviction, document 417. So it's $2,962.81 to the victim's mother, CS. Crime victim compensation is $5,000. Total is $7,962.81. Restitution surcharge is $796.28 for a total restitution of $8,769.09. The attorneys can have 21 days to write a memo to the court if they think any of the credit applies. But it's the sentence of the court that you be imprisoned in the Wisconsin State Prison system for a term of life imprisonment. The court, in its written explanation of determinate life sentence, is going to fill in a period of time where you can apply for parole eligibility. I've checked that box. You are eligible for release to extended supervision, eligible for a hearing. It's not an automatic granted. After serving 36 years, 0 months. Part of that decision on that amount is not just based on your violent history in the past, but also the seriousness of this crime, the aggravated nature of it. And in some symbolic way, 36 years is roughly where Joey was at. And it's the court's hope that over the next 36 years in the confined setting, you try and help others persevere. I think Joey was in favor of that. He tried to help others. It's clear from his words today to his sister that he was in favor of people, whether it was through religion or other means, doing better. And I think he would be hopeful that you, on your confinement time, try and better yourself and maybe some of the people you're with. So you are eligible for release to extended supervision, eligible for a hearing after 36 years, 0 months. That's consecutive to any other sentence. This is a separate and distinct crime. The court will give you a copy of that written explanation of determinate life sentence. There's also an explanation of the petitioning process for release to extended supervision once you're eligible. Bring that over to the table. Court costs, including the DNA, are automatic, so we'll order that. That can be collected on extended supervision. At least at this point, since it's a consecutive sentence, it's the court's initial belief that credit doesn't apply. Is that correct, Ms. Templis? Ms.
Correct.
Rock? I'll give you 21 days to do a petition for credit. All right, anything else you need clarified for the record, Ms. Templis?
As it relates to the restitution hearing, if a restitution hearing is requested after all the documents have been reviewed, can it just indicate whether it's a request to challenge the amount, which would require testimony, or if it would be an ability to pay argument so that we can make sure we're
All right,
prepared?
and I'll give Ms. Rock 21 days to do that. Is that enough time?
Yes, that's fine.
Anything else the prosecutor needs to bring to the court's attention?
No, thank you.
Ms. Rock, anything you need clarified from the court?
No, thank you.
All right, and the court appreciates everybody in attendance. We were able to conduct this hearing without disruption. And once again, as the prosecutor said up front, I think she phrased it, there's no winners here. The court takes no joy in being involved in this process, but desire is tempered and reasonable justice, and that's why I went longer to try and make a record of that as much as I could. So with that, we're in an adjournment, and the deputies can take Ms. Krebs back into custody.